Okay, admitting folks, and we are now recording.
Okay, thank you. Good morning. My name is Victoria Hasid, and this meeting of the Agricultural Labor Relations Board is now called to order. Please note that all meeting participants and members of the public will need to select the language they prefer to listen to the meeting in. Please look at the bottom of your screen and select the interpretation button on the bottom right. Please click on that and you can select either English or Spanish. Even if you are able to hear me now, you need to select your preferred language to ensure you are able to hear audio for the duration of the meeting. I will now turn this over to our Executive Secretary, Santiago Avila Gomez, to relay this information in Spanish.
Thank you. Para miembros del público que quieren escuchar nuestra audiencia en español, hay esa capacidad dentro del programa de Zoom. Si por favor ven hacia su pantalla abajo, van a ver un botón que dice interpretación. Por favor, elija ese botón y elija español. Aunque quiera escuchar en inglés, si ese es su propósito, por favor, elija inglés.
Thank you, Santiago. Next, I will turn to the roll. Board Member Broad?
Here.
Board Member Flores?
Present.
Board Member Hall? Okay. Board Member Lightstone?
Here.
Also present from our staff for today's meeting is again our Executive Secretary, Mr. Santiago Avila Gomez, who is providing technical support. We are living in rapidly changing times, and the board is committing to taking the steps necessary to protect the health and safety of both our staff as well as members of the public. In accordance with the new Executive Order N-122, today's meeting is being held via video conference with an option for members of the public to dial in. At the close of the business portion, we will open the meeting up for public comment on any portion of the meeting. Members of the public who have contacted the board either by email or phone and asked to be placed in the public comment queue will be called on in order received. If you did not previously contact the board and wish to make a public comment at the end of the meeting, you may do so in one of several ways. You can make a request in the Zoom chat function or raise your hand or email Santiago Avila Gomez to be placed in the queue for public comment. Please note, we ask that you use the chat feature only to indicate that you wish to make a comment. Substantive comments in the chat will not be made a part of the public record. We ask that you also provide your name and organization if applicable. This information will become part of the official record of today's proceedings. If you wish to speak more than once, please alert staff and have your name placed back in the queue if you are able. If you're having technical difficulties when you are called up, please reach out to us via the Zoom chat function or email, and we will do our best to come back to you. We do have limited capabilities for managing participation during the meeting and during the public comment period. So we're asking everyone who is not speaking to place their phones or Zoom on mute and wait to unmute until you are called to speak. You can also see these instructions on our agenda, which is posted online at alrb.ca.gov, which is located on the ALRB homepage under News and Information. You can also see the agenda for today's meeting, as well as all related reports on our webpage under the Meetings tab for public notes and minutes. Okay, so proceeding to our first agenda item, approval of the public meeting minutes from December 14th, 2021. May I have a motion to approve the minutes?
I'll move that.
Thank you, Member Broad. So motion, may I have a second? Thank you, Member Lightstone. All those in favor say aye.
Aye.
Aye. Thank you. The minutes are approved. Okay, the next item is the chair's report. First, I want to say it is great to be back. I have been out of the office on parental leave since August. And while I have very much appreciated and enjoyed my time bonding with my 6-month-old daughter, it is nice to be back at the ALRB. I want to take a moment to thank Chair Lightstone Acting Chair Lightstone for serving as the chair in my absence, and to all the board members and staff who worked so diligently to ensure that we were operating smoothly in my absence. You may have shown that you don't need me, but I appreciate it all the same. So thank you so much. I also want to take a moment to acknowledge that we are in Black History Month. We see more and more every day how important it is to know our history and how much it affects things in the present. I also want to note that the governor's appointment secretary and former board member, Catherine Rivera Hernandez, took a moment to honor the Newsom administration's African-American appointees, including our own board member Hall, who we're so excited to have on our board and who helps bring a perspective that we would not otherwise have, which is so important, and I think something that we need to acknowledge during this time. And with that, that concludes the chair's report. I will move on to the next agenda item, which is the executive officer's report on elections, unfair labor practices, complaints, and hearings. Mr. Avila Gomez.
Thank you, Chair Hasid, members of the board. I will commence with the election activities. There have been no notices of intent to organize filed since our last board meeting, and there's been a petition for certification filed in Sonoma Cho LLC, doing business as Floraterra. The case number is 2022 RC 001 SAL. Teamsters Local 665 filed their petition January 14th, and an election was held on January 21st of this year. As you'll hear later, the matter is now pending before the board. With respect to complaints and specifications, there were 5 complaints and 1 specification filed. The 5 complaints are 1 Norma Stretch, doing business as Dixieland Orchards, case number 2021 CE010 VIS in Madera County. That was issued by the General Counsel on February 11th of this year. The next is Tree Sap Farms LLC, doing business as Everyday Growers. That's case number 2021 CE019 VIS, and that's in Yolo County and issued on February 11th of this year. Next, Camus Vineyards, case number 2020 CE001 SAL. That's a Monterey County matter, and it was issued on December 17th of 2021. Next, Primetime Packing LLC, case number 2019 CE017 BIS, and that is in Riverside County and also issued on December 17th, 2021. Finally, Tanimura and Antle Fresh Foods, Inc., case number 2020 CE047 SAL, and that was a Monterey County matter, and it was issued on December 16th, 2021. With respect to specifications, and specification was issued on December 27th, 2021, and that was the Rincon Pacific LLC, relating back to the board's decision in 46 ALRB number 4. The case number for this is 2014 CE044 SAL. Matters settled by the General Counsel include Tanimura and Antle Fresh Foods. They entered into an informal bilateral settlement agreement on February 16th of this year. Coast King Packing LLC, case number 2020 CE016 SAL. SAL. Also, the parties entering into an informal bilateral settlement agreement, and that was on January 28th of this year. Next is Guest Cattle Company LLC, case number 2020 CE008 VIS. Parties entered into an informal bilateral settlement agreement on January 17th, 2022. And then finally, Rincon Pacific, which I had just mentioned, the respondent in that matter agreed to fully comply with the board's decision of 46 ALRB number 4, and they indicated that they would comply on December 31st, 2021. Since the time of our last public board meeting, there have been no complaints withdrawn. There haven't been any hearings held or administrative law decisions issued. There have been no board decisions issued. There was 1 administrative order issued in Rincon Pacific LLC. That admin order is ALRB Admin Order 2021-11, again, relating back to 46 ALRB number 4. And the board issued its admin order certifying good cause to exceed the time limit of Labor Code Section 1149.3. That order was issued on December 15th, 2021. Finally, pending matters before the board includes Cinegrow Farms, Inc., case number 2017 CE008 SAL. Briefing was completed in that matter on December 13th, 2021. It's pending before the board. Also pending before the board is the election matter that I earlier referred to, Sonoma Cho, LLC, doing business as Flora Terra. This report, as well as other reports as mentioned by the chair, are available at the link that I posted in the chat, and it's on our meetings landing page on the ALRB website. That concludes my report. Happy to answer any questions.
Thank you so much, Santiago. Do any of my colleagues have any questions? Any members of the public? Okay, next is agenda item number 5, which is the litigation report, which will be reported on by Chief Board Counsel Todd Ratchin. Todd?
Good morning. Thank you. Can you hear me okay? Okay, excellent.
Yes, we can.
Since the last public meeting in December, a couple litigation updates. We've had 2 matters argued in the 5th District Court of Appeal. The first one involves Wonderful Orchards, case number F081172, which is a challenge to the board's decision in 46 ALRB number 2 that was argued on January 25th, and we are currently awaiting a decision from the court. And then in another matter that was argued on February 10th involving United Farm Workers' challenge to the board's order decertifying it as the representative of Ground's agricultural employees. The union's challenge to the board's, this was a challenge to the board's orders in 45 ALRB numbers 4 and 8, finding the union committed an unfair labor practice when it threatened to picket Ground if it did not recognize the union as the bargaining representative of its employees. The 5th District case number is F080469. And so the arguments were held on February 10th, and last Friday, February 18th, the court issued an unpublished opinion dismissing the union's arguments and affirming the board's orders. The deadline for any petition for review in the California Supreme Court from that decision is March 30th. And that is the litigation update.
Thank you, Todd. Do any of my colleagues have any questions? Any members of the public? Okay, next we'll go on to the General Counsel's report from General Counsel Julie Montgomery. Julie?
Thank you, Chair Hasid. Good morning, everyone. Good to see you all back and have our chair back with us once again. I'm going to start, as I usually do, with some updates regarding our personnel vacancies. In the General Counsel program, we have 2 vacant outreach positions in Salinas and Visalia. We have attorney positions available in Santa Rosa and Visalia offices. We have a field examiner position in Salinas and a legal secretary position in Oxnard. So please help spread the word. If you know of anyone, our postings are on our ALRB website. There's a link on the left-hand column under job opportunities, and we very much appreciate a broad pool of applicants. So I would love help with publicizing that to anybody who can do that. I am now going to report on our settlements that we've achieved in the General Counsel program, as I usually do. And this past period, since the last board meeting, we have achieved 9 settlements in our regional offices. And so I'll just briefly summarize what those entailed, as otherwise many people don't know about the work we're doing because they don't end up being published currently on our website. So the first one, as our executive secretary mentioned, was a settlement with Coast King Packing LLC. And in that case, a lettuce harvester in Monterey County alleged that Coast King discriminated against him and a coworker for refusing to call them back to work after they filed a charge with the ALRB and cooperated in the ALRB's investigation. So the ALRB did issue a complaint in that case, and we settled with the company before hearing for back pay and payments in lieu of reinstatement for just a little bit under $18,000 for the worker. Additionally, the company agreed to the standard remedies of reading, mailing, noticing, and posting to all the agricultural employees harvesting romaine lettuce in Monterey County. We also achieved a settlement of a complaint that we filed recently against Tanamura and Antle Fresh Foods, where a worker weeding vegetable crops in Monterey County alleged that that company had retaliated against her and others for speaking up about working conditions and encouraging coworkers to defend themselves against supervisors. The ALRB investigated and issued a complaint, and the company entered into a pre-hearing settlement rescinding disciplinary notices. And the company also agreed to the standard remedies for mailing, reading, noticing, and posting for all agricultural employees performing weeding and thinning work in Monterey County. We also achieved a settlement for a strawberry harvester who filed a charge in Ventura County against at Chandy Farms, claiming that they retaliated against her by changing work assignments after she spoke up on her behalf and behalf of others about access to water, bathrooms, and other working conditions. And then she amended her charge to additionally allege that the company didn't rehire her because she spoke up about COVID-19 relief pay. And so they did enter into a pre-complaint settlement for the full amount of back pay owed, and as well as a 1-hour training on the ALRA to supervisors, as well as a reading, mailing, and posting of the notice. And also a strawberry.
Pardon me, Julie. Can you repeat the employer and charge number for that again? That last matter.
Don't have a charge number at my fingertips, but it was at Chandy Farms, and this was a pre-complaint settlement. So there was no complaint filed. It was just a charge. But yeah, I can find the charge number, but I don't have it in front of me.
That would be great. Maybe that can be shared at our regional director meeting later.
Sure. Yeah, I'm happy to do that. Mm-hmm.
Thank you.
Sure.
Sorry for interrupting.
No worries. And we also settled another charge against the Chandy Farms for another strawberry harvester who claims that the company retaliated against him by issuing him a disciplinary ticket and terminating him because he spoke up for himself and others about a crew leader mistreating him and his coworkers during a reading of the ALRB notice. And the company did enter into a pre-complaint settlement in that case and paid the total back pay amount of a little over $1,300, as well as an offer of reinstatement to the charging party and his wife, who claimed they were retaliated against. And they also agreed to the standard reading, posting, noticing, mailing remedies, as well as a 1-hour supervisor training for the company's supervisors. The general counsel staff also reached a settlement, as you heard, with Rincon Pacific, in which they agreed to pay the full amount of the board's order, and we received checks and payments for the workers in the amount of $123,585, and so those payments have been received by the regions. And in that case, it involved an order that the company, a board order finding that the company had retaliated against the workers, a group of workers, a crew of workers, for engaging in a work stoppage. Additionally, moving on to Visalia region, a livestock worker in Tulare County filed a charge against Guest Cattle Company, alleging he was fired for complaining on behalf of his coworkers about wages and overtime. And the ALRB investigated and filed a complaint after determining that a violation did occur. The case settled shortly before hearing, and the employer agreed to pay the worker $7,500, which was the amount of back pay and payment in lieu of reinstatement. And the employer also agreed to standard remedies of noticing, reading, mailing and posting. Some pistachio and almond harvesters in Kern County filed charges against Parsons Farms, alleging they were retaliated against for reporting sexual harassment to their supervisor. And they claimed that they were transferred to less desirable work locations, doing more difficult work as a result of those complaints. The parties entered into a pre-complaint settlement agreement. And the company agreed to respect and not interfere with employees' rights that are protected under the Agricultural Labor Relations Act. And they also compensated workers for work losses they alleged of about $7,400 and standard remedies of reading, noticing, mailing, and posting. We also achieved another settlement for a worker in Fresno County who was working in tree fruit orchards for Scott Raven Farming. And that worker claimed that his employer retaliated against him and a coworker for complaining about the crew having to work in extreme heat conditions. The ALRB and the company settled to compensate employees for losses in the amount of $1,280, which was the full amount of the back pay and standard noticing remedies. And that was a pre-complaint settlement. A citrus worker in Fresno and Tulare counties, this is another case, also filed a charge against DCR Farm Management, alleging he was fired for complaining about supervisor mistreatment and for asking for wage increases and protective equipment on behalf of his crew. The company entered into a pre-complaint settlement with the ALRB to compensate the worker for his losses in the amount of $1,294, and then the standard noticing remedies that I previously mentioned for the other cases, and for the ALRB to conduct a training of that employer's supervisors. So those are our settlements that our regional staff have been working very hard to effectuate during the past couple of months since the last board meeting. As always, we want to resolve our cases as expeditiously as possible. And it's always a good thing when our charged parties agree to resolve these matters informally and just get money and remedies to the people affected more quickly. I'm also going to give a brief update on a subpoena enforcement action that our Salinas region filed in Monterey County Superior Court. And that involved a group of charges filed by some workers against the United Farm Workers. And in that case, oral argument is scheduled to be heard Friday, February 25th. And in that case, the ALRB, in its investigation of various charges, requested documents from the UFW to aid in our investigation of these charges, which were filed by workers at Monterey Mushrooms. And they alleged that the UFW retaliated against them in the operation of their hiring hall because of the workers' prior participation in a campaign to decertify the UFW. And although the UFW did provide a number of documents in response to the ALRB subpoena, several disputes remain, which we were unable to resolve informally. For that reason, we did file for enforcement in Superior Court, and the court will decide those issues after our oral arguments this Friday. And so those are my case-related updates, and I was just going to move on to some outreach updates if there's no questions about the cases.
I have one question on I think it was against Parsons. It was a settlement related to sexual harassment,
Yes.
and workers alleging they were that then impacted their work assignments. Do we know if there was a farm labor contractor involved in that particular matter?
Yes, there was.
Okay. I asked just because in my previous life at the Department of Industrial Relations, there were several pieces of legislation really focusing on sexual harassment prevention training for farm labor contractors. And it sounds like there was settlement reached in this case, or that's what you reported. So that's wonderful. And I always think that is the most expeditious way to handle it. But to the extent it's applicable, I think references or referrals over to the labor commissioner so that they're aware when those cases involve farm labor contractors are always prudent. Okay, thank you. Any other questions on cases from my colleagues? Okay. You were going to give us an outreach update as well.
Right. And I just want to mention that is what our staff does. We always look for other resources available for people in such situations. And when there's a claim of sexual harassment, we will also refer to the Department of Fair Employment and Housing when appropriate for investigation as well. So we don't usually settle these in a vacuum especially when there's serious allegations like sexual harassment. So I just wanted to put that out there that we do look to give referrals to our sister departments in such situations. So I'll now move on to a summary of our outreach activities. And although we're down a couple of outreach staff that we're of course seeking to fill, as I mentioned earlier, our staff has nonetheless been very busy pulling together to conduct outreach in these difficult times where, again, things largely shut down between December and February. But nonetheless, our staff have really done what they can to get the word out to our stakeholders. And I just really want to give a shout out for all the wonderful efforts, and in particular for the efforts of our outreach manager, Daniela Ramirez, for coordinating all of these activities. And just to give you a brief summary, they have been distributing we have some ALRB cards, or poster board cards with information about the workers' rights working with COVID-19 and how that interfaces with their rights under the ALRA and some other basic rights regarding working in a pandemic. We have distributed, looks like they counted 285 of those cards at 3 in-person events, including a resource fair in Imperial County, a Ag World Expo event in Tulare County, and also at an organization in Ventura County, Poder Popular Lucha, it's called, in Ventura County. So they've been getting those cards out. Additionally, they have distributed an additional 3,350 of those cards through community-based organizations, libraries, and other groups, including some nonprofit service providers in Fresno and Monterey County, for Centro Binacional para el Desarrollo Indígena Oaxaqueño, the Mendota Library in Fresno County, Proteus Kerman Service Center in Fresno County, Todec Legal Center in Riverside County, and also the Poder Popular Center in Ventura County. They conducted an appearance on Spanish and Indigenous language radio hosted by KBBF in Sonoma County. We also conducted 2 training presentations to community-based organizations in Spanish, including 2 Puertas Abiertas in Sonoma County and Líderes Campesinas in Monterey County. And so that's just a brief overview of some of the outreach we have done. Of course, like I said, the opportunities have been more limited during the past couple of months, but as things begin to open up more, I think we'll continue to get out there and also as well continuing our outreach through radio, television, and social media.
Thank you. I don't have any other questions. Do any of my colleagues have any questions? Any members of the public? And I was remiss, since I was out, I believe just a couple of weeks ago, our general counsel was confirmed and approved by the Senate. So I want to extend congratulations, and we're very pleased that she will be serving again in another term. So thank you. Congratulations, Julie.
Thank you very much.
Oh.
Appreciate that. Glad to be here.
And shout out to our outreach staff. I know these are challenging times, and I am always very impressed by the amount of work that they're able to do with limited resources and during a once in a century pandemic that unfortunately seems to keep throwing us curveballs. Okay. Next up, the next agenda item is our Division of Administrative Services report from our Chief Administration, Brian Dougherty. Brian?
Good morning. I just have a few brief updates from the administration side. Most of the updates today are going to be kind of providing some updates on facility projects that we've been having ongoing work with the Department of General Services and completing for the General Counsel program. In our Oxnard office, we have completed a update and site search for a new dedicated location for our Oxnard office. We're currently co-located with the California Uninsurance and Appeals Board space, which has kind of limited space and is not as friendly for the public to be able to come into. We have identified a space across the street where we can have our own dedicated office. So we're currently working on with the contractors on getting that space ready, and we anticipate as early as the end of April that we may be able to move into our own dedicated Oxnard office in that location. In the Visalia area, we're currently working on a renovation to the existing office that we are in. We have got plans to be able to go into that office and install all new modular units, all new furniture, and update the flooring and painting as well. In addition, we have made arrangements with the lessor to build an outdoor shed storage unit that will allow us to be able to remove some of our elections equipment, such as voting booths and some of our larger, bulkier items out of our office space and be able to store it more appropriately in a storage container that will free up additional space within the office to make the more usable space within that Visalia office. We anticipate those renovations being completed similar time frame on the Oxnard, end of April, early May. And then lastly, the latest update on our Salinas office. This is probably our largest facility project we have going right now, and this is an office expansion where we're actually going to be expanding the office into the next suite next door. We are anticipating there's going to be quite a bit of construction involved with this expansion. Currently, in working with DGS and the construction crew, we're anticipating that it's probably 1 to 2 weeks of construction, which will most likely require us to close the office. We're still in the planning stages as they're still in the process of finalizing building permits. And we're awaiting kind of an updated project timeline, which will be communicated so that we can ensure that we minimize impacts to our operations, given that we will have to close the office and work remotely for a period of a week or so during that process. Lastly, one additional update on the facility size is related to our headquarters office. We have been included as part of a larger statewide building renovation project that's impacting the Labor and Workforce Development Agency. There's process in place to update and renovate the resources building that's located on O Street in downtown Sacramento. And as part of that project, it will include the consolidation and movement of the EDD office on Capitol Avenue ALRB and the LWDA offices to basically take over the entire resources building as part of that renovation project. There have been preliminary floor drawings that have been started. And currently, like I said, everything is still in the very early stages of this project. For the building renovation, it's going to be a complete gut and remodel of that existing office building, including seismic updates that are going to have to be done as well. So it's a major construction project. We're currently slated to be put on the 16th floor of that newly renovated building, and we will be co-located with the Labor and Workforce Development Agency. So we'll have our own dedicated suite, but the Labor and Agency will also be co-located on that floor as well. Right now, the construction timeframes are still very preliminary, but the timeframes that are being shared with the departments are they anticipate the construction and renovations to be completed probably in early spring of 2025, with the earliest move-in date for departments being the summer of 2025. This is a project that has been kind of started and stopped a couple of times due to the issues associated with the pandemic and some of the budgetary issues, but the project is now fully funded and is beginning in December has started kind of the expedited planning and approval processes. So as additional information is shared on timelines and additional drawings and such are completed, I'll be sure to share that out with both the board and the rest of the executive staff. And with that, that kind of concludes the updates I have on the administration side, and happy to answer any questions anybody may have.
Thank you so much, Brian. I don't have any questions. Do any of my colleagues have questions? Any members of the public? Okay, thank you so much. Moving on to the next agenda item, it is number 8, the legislative report from our Chief Board Counsel, Todd Ratchin. Todd?
Currently nothing to report, Chair.
Okay. And next up is our agenda item number 9, an update on regulations from the Regulations Subcommittee. I want to note the time. It is about 10:40, and the interpreter has let us know they will need a break around 11 a.m. So I imagine we'll be taking a quick recess around that time and probably still discussing this topic, as I know there's quite a bit of things to get through. So just flagging that. And I will now turn it over to the Regulations Subcommittee, Board Member Broad and Board Member Lightstone.
Okay. So let me begin with a couple of preliminaries. The most important of which is that our regulation process so far, the entire thing has been preliminary. That is to say, it's pre-rulemaking. So we've spent a year developing regulations, meeting with stakeholders, getting written and responses from stakeholders, periodically coming back to the board with reports and requesting direction of where to go. We are now at the place where we have a proposed regulation package, which, if the board approves it today, we would actually begin the formal regulatory process. So it's important to understand that there will be numerous occasions to make comments going forward. So anyone who feels like, well, maybe I should have made a comment in the previous period of pre-rulemaking investigation, you're certainly not lacking an opportunity to comment in the future. And when the board promulgates these regulations, as we're recommending they do today, the board can listen to feedback, consider issues, and change the regulations. So at this point, nothing is cast in stone, and I want everybody to understand that. That said, this is a big regulation package, and a kind of an ambitious project, and it took as long as it took because we really wanted to make sure, at least going into the formal part of it, that we had an opportunity to meet with all our stakeholders, which is everybody. It's not just the external stakeholders, but our staff, in the various parts of our staff, the administrative law judges for their input, the general counsel's office for its input, our board counsel for their input. So, and we did have a lot of meetings and listened to a lot of discussion. So let me just take a second and first of all, thank our board counsel and particularly our chief board counsel, Todd Ratchin, for helping us develop these proposals and working through the problems and trying to come up with a package that that was workable and made sense. And I want to thank the public, the people who gave us input, because it was very, very helpful in moving forward. So that said, you have before you this proposal. It was last before the board in October, September, and then October. And most of what was before you then is unchanged. And in the reports that you have of the various regulatory proposals, any changes that we made to what you saw then is outlined in red ink. It isn't, there's not a lot of changes, and they're mostly what I would say are non-substantive, technical, grammatical, those sort of changes. So most of what is before you has been before you for, you've seen before, and the public has seen before and for quite a while. To characterize the whole thing, the vast majority of what we're doing here is things that are technical, grammatical, and we're trying to, are substantive, but are trying to update our process, eliminating, facilitating more electronic filing, eliminating antiquated forms of communications, you know, like telegrams and things like that, so that our process is more efficient for our parties, is more seamless. We're not requiring, 6 copies and, burning reams and reams of paper, which is very good for the environment, and moving towards the sort of electronic filing that is now commonplace throughout judicial processes in this state and country and world, for that matter. So that's mostly what we're doing here. There are some substitute proposals. There are proposals that I'm sure are controversial. I'm not going to go over everything in the package. During the discussion, we can, if anyone wants to raise issues, obviously we're happy, to talk about them. I do want to go over 2 things, which is 2 proposals that after significant discussion and debate internally between Member Lightstone and myself as the subcommittee, we decided to table or suggest tabling at this time. And I want to go over the 2 of those. The first was our proposal for regulation 20220, excuse me, which was a time limit for the issuance of complaints by the general counsel. After going over the statistics over the last 5 years of sort of where we've been, 2 of which happen to be the COVID years, which I think by any estimation somewhat were abnormal years and not likely, and created all kinds of different conditions than normally exist. The number of filings of charges went down. There were obviously issues with people who got COVID, or relatives who got COVID, parties who got COVID, farm workers who got COVID, witness, everybody, COVID really affected everything. So it's a little hard looking at the last 5 years to say we have a sort of a true 5 years worth of average kind of data. Nonetheless, we concluded that the general counsel, excuse me, had done an admirable job of eliminating a backlog of the very oldest cases. And these, in some instances, were cases in which a charge was pending for 3 or 4 years. And in discussions with her and her staff, it's clear to the subcommittee that she is making an effort, a significant effort, to try to shorten the time that it takes for cases to be processed. So on balance, what we recommend is postponing any formal imposition of a time limit for filing of complaints, and see where we go in the next year. We would like that to be coupled with during the reports from our regional offices, and I don't know whether it would be on a monthly basis or a quarterly basis. That's still, I think, to be discussed internally. We would like to have as a permanent feature of those reports case aging statistics. So we're able to really track how long it's taking cases to move. Now, I'm not saying anything is easy, but it's easier to target the very most distant cases with the, that have very outsized times and focus on those cases and eliminate that caseload. That doesn't mean necessarily, however, that the far more difficult job, realistically, which is looking at cases that take between 1 and 2 years, or maybe slightly older 2 years, and there are many cases like that. It's shortening those cases. And some of those cases are necessarily longer because of the seasonal nature of our workforce, and people leave sometimes. A lot of charges are filed at the end of people's employment with a particular employer in a given year. They don't return for another year. Sometimes it takes a while for them to get back and where they're in contact. They leave the area, they move on. It's hard to get a hold of them. But we do, I think, feel as a subcommittee that we need to move towards a culture of moving these cases expeditiously as possible, that this system will work best if charges are dealt with thoroughly. I mean, we don't want to short shrift any investigation, and I want to make that very clear, but expeditiously. Because if it takes a year and a half or 2 years for a charge to go from a charge to a complaint, and then there's a further investigation and it goes a period of time, and then it goes to a hearing before an ALJ, and then, God forbid, somebody decides to appeal it to the board, and then we issue a decision. We're talking about a very long period of time between the time that person first made the charge and the time that their case is resolved. And so we do want to see these cases move faster, but we also, this is within the way cases move and how they're investigated is totally within the purview of the general counsel's office. We can't order the general counsel to do things with her cases, but we can make an observation and have made an observation and had that, we want to see these move more quickly. So that's our recommendation, that we postpone this for now, that we revisit in a year when we can look at statistics for 2021 in full and 2022 and see where things are going and what the trajectory is for the movement of cases. This is not, and I want to make this very clear, this is not, we're saying we're dropping it temporarily, but we are really just going to forget about it. That is not the intention of the subcommittee. It is certainly, as one board member, would not be my intention, because it's a very important issue. The second issue that we decided to recommend that we not go forward with, there was a proposal to allow the filing of anonymous charges. Currently, under our system, when someone files a charge, that charge is a public document. That's available. It's available to the employer. It's available to the world, more or less. So they're going to know, the employer is going to know. Now, there's a very good reason to permit anonymous charge filing, and that is it will encourage people to come forward who are otherwise intimidated and who, may be intimidated by the knowledge that they're filing this charge, and there's some time that elapses between when the charge is filed and when and if a complaint is issued, and that they're in a kind of vulnerable position. And we very much recognize that problem. There are, however, a series of countervailing factors that caused the subcommittee to make the recommendation it's making. One of them, and I'll go through them very briefly. The most important is that when your name is known to the employer, you are granted a great deal of protection in the law, because anything of a retaliatory nature that happens to you after you file a charge is going to carry with it a big burden that it was not done for an illegal or discriminatory purpose. And is completely unrelated to the fact that you filed a charge. If the charge is anonymous, then let's say that the charged party is an employer, which usually is. If the charged party is an employer, they can potentially engage in retaliatory conduct and say, hey, I didn't know anything about a charge being filed. I just fired that worker because they weren't doing a good job, or demoted that worker or didn't give that worker a raise that I gave somebody else, because I had no idea that they were filing the charge. So that's one problem. It may actually inadvertently strip the worker of a great deal of protection. They will, if a complaint issues, they will not be anonymous. So at that point, once the complaint issues, there's no more anonymity anyway. And it may be, and this is a second issue, is that the very nature of the charge itself is going to reveal to the employer who the charging party is. Because if it says an anonymous person filed a charge saying that a single person was discriminated against in their employment for complaining about something, they're going to know right away that that person is likely could be the charging party, because they're certainly the person where wrongdoing has been alleged happened to them. And so then there's kind of maybe a false sense of security that there's some anonymity, when in fact everybody actually knows who it is. And then as the board investigates, if they try to protect the person's anonymity, they maybe kind of get into a psychology in which they don't ask for certain documents or records, or feel a little bit hesitant because it would reveal the identity. And and finally, there's a series of issues, and this is all outlined in our report, but there's a series of issues related to discovery, which is discovery has to be within the confines of the facts alleged. So then if the general counsel is starting to ask for individual documents, the case could kind of get gummed up by the charged party by saying, well, wait a minute, who is that person? I don't know who that person is. What does that have to do with the charge? Why are you asking for that? What's relevant about that? And it just becomes complicated for what may be a very short period of anonymity to begin with. So for those reasons, we decided to not to move forward with this proposal. We would note that we discussed, and this would require a legislative change, a better approach, at least we thought maybe a better approach, would be to change the statute, if this is really necessary, to allow the general counsel to investigate a charge, essentially to investigate their own charges without a formal charge being filed. In other words, if they come across information, that they would be able to file a charge, much like the police file charges. They assemble facts. Sometimes they get a tip. Sometimes they get it's information, from another case. They get it from another agency. There's no charging party, but if somebody from Cal OSHA informs them, hey, we were working on health and safety, and we noticed that that a whole group of employees, after we showed up, had been terminated, and for what we thought might have been concerted activity. It's maybe something you ought to take a look at. That would require a statutory change. And so it's nothing that we can propose, but it is something that could be considered if brought to the legislature. So with that, I'll conclude my remarks. I'm going to kind of hand this now over to the full board for discussion and for commentary by the public. I know our general counsel has some things that she would like to say, so I hope that maybe we can begin by having comment from her.
Yes, I think in the interest of the interpreter needing to take a break, what if we pause here? It's 11:01, take a 10-minute break, and so we'll come back at 11:11. And then we can turn it over to the general counsel, I think, for first comments. I know that there's a memo, which you can also see posted on our website, that I'm sure she'll expand upon. So we will take a 10-minute break, and come back at 11:11. Thank you. Okay, thank you. We are now back after a 10-minute break. Let me just check in with the executive secretary before we continue. Santiago, any issues or any technical issues we need to be aware of?
No, not at this time.
Okay, all right. And then Member Broad, Member Lightstone, did you have any other update as part of the regulation subcommittee before?
Not for now. Let's hear what folks have to say.
Okay, we'll turn it over to General Counsel Julie Montgomery. Julie.
Thank you. And I appreciate the opportunity to address this issue. And I just want to start by saying that I share the board's concern with the length of time some of the investigations have taken. And my executive staff and I have been thoroughly reviewing our operations and procedures as to how we how we oversee the program in order to make changes to increase the efficiency of investigations and provide more support and oversight to the regional office staff so that we can shorten those timelines. And I have made a number of changes as a result of those efforts. So I just wanted to outline a few things I've done because it really is important for these investigations to be completed as quickly as possible. And of course, there are, like Board Member Broad mentioned, there are a number of situations in which delays are really out of the General Counsel program's control. But to the extent we can tighten some of those timelines and be more efficient with our processes, we want to do that. And so I have made changes to our procedures to facilitate that end. And so these changes really fall into two broad categories. One is that we have centralized our calendaring and tracking system for investigation related deadlines that we set. That the General Counsel program has always had that function be executed through the regional directors and overseen by the regional directors locally at each office. And just upon further review and discussion about that system, we found that it does create difficulties given just the extraordinary amount of responsibility that the regional directors have in so many different areas. So to help facilitate that oversight and tracking and assist the regional directors with this, we have centralized that function through the Sacramento headquarters office so that instead of just being tracked at the regional office level and overseen by the regional directors, we are now tracking and overseeing those functions through Sacramento staff. And we are calendaring deadlines and just following up with folks in the regions through Sacramento, just so we can alleviate the regional directors in some regard from that function. Although, of course, they're still integrally involved in the progress and status of investigations, and the regional directors and their local analysts are assisting with those efforts. But there's coordination now. There's a lot more coordination between the Sacramento analysts and myself and my headquarters attorneys with the regional analysts and regional directors, so that we're in much closer communication. There's more regular review and tracking of these timelines, and also just making sure that that we're communicating more regularly with staff who are assigned these investigations to make sure that they're staying on track and that they have the support and resources and assistance that they need through the investigation, so that there can be more communication, so that when difficulties arise, they experience a challenge, that we're checking in with them more regularly and making sure that we're addressing those issues. So thus far, I've been very pleased with how this has been working out, and our new systems seem to be resulting in improvements in that regard. So I've been really happy about that change. The other major change we've made to our operations is in how we oversee the casework in the regions, generally speaking. And again, previously, the system was that everything went through the regional director, and the regional director would review and provide feedback to pretty much everybody before it would ever get to me or to other headquarters staff. And we found that was resulting in a backlog, again, because the regional directors are very overloaded and they have a lot of responsibility. So to avoid backlog from occurring in that regard, or at least to reduce it, we have changed some processes as to how we review casework, and centralizing that function a little more so that we can look at things that need to be done and decide who is the best person to assist someone with review and oversight in the event that the regional director is overloaded or any one person is overloaded. So we're working to disperse that a little more throughout the program leadership so that people can get more assistance and oversight without having to wait until one person, so there's not a bottleneck, it's just one person basically. So we've changed that process as well. And again, I've been pleased with how that has been working. We also are just continually assessing and monitoring the training and mentorship needs for the regional staff, and just looking at where do they need help, where do they need training, what more resources can we provide, either through external training opportunities or internally. And of course, we always have some turnover of staff. So even if we conducted a training a few years ago on a particular topic, there would be a lot of new people that haven't received that training. So we need to keep offering it, and just really tracking and using our analyst staff to help us track those efforts as well. And I've held meetings with various I've held meetings with the attorneys and the field examiners in the regions to get more input and feedback on what their needs are and ideas as to how we can improve our systems. So I've been talking to the staff, listening to the staff, and getting their ideas as well as to what can we do to provide more support and just improve our processes, because we all share the same goal. I mean, the staff as well, I've heard from them that they feel that it's a huge priority for us as a program to be faster, and everybody wants it. We just need to make sure that we have good systems in place so that when things really, I mean, they're always busy, right? when we're really overloaded in particular, that we have a good system in place to better track and not have things fall off the radar, and make sure that they keep moving, and that progress is moving forward in these cases as it should. So I'm pleased with what we've seen so far, and I'm very optimistic that going forward, when we look back on last year and say this year, we will see improvements in the timelines from before, and going forward, assuming that we can continue with these procedures. And like I said before, we're continuing to refine and we'll tweak things as needed, because you could always have a good idea in theory about like, oh, this would be a great plan, but then in practice you often hit road bumps and realize that there's factors you didn't consider. So we're continuing again to take input from the staff, listen to folks, and see how things are going, to make sure that that these processes are running more smoothly, and that we can continue to have better outcomes, so that when there are delays, that it is for factors beyond our control. and not because we because we caused it. And that's my end goal. And like I said, I'm optimistic that we will get there. And I am more than happy to provide and have the regional directors provide periodic reports about the age of our investigation. I think that's a really good idea for us all to be on the same page and have the same understanding about what is the status of these investigations, and ensure that we're all working with the same data sets. So I didn't know if there are any questions, but those are just the comments I wanted to make about that issue.
I'll open it up to my colleagues. Does anyone have any comments or questions? Board Member Flores.
Thank you, Chair Hasid. I just wanted to say thank you to the subcommittee for their thorough and thoughtful approach, and also thank you to the General Counsel for her report on this specific proposed regulation this morning. I think we're headed in the right direction and fully on board with the subcommittee's recommendation this morning. Thank you.
Thank you.
Thank you. I have a couple of comments and questions, some on the package as a whole, and then I'll save my comments on this particular regulation because they're more in-depth, or proposed regulation for the end. So one, I echo Board Member Flores' comments, thanking our subcommittee as well as our staff, our board councils who've worked really hard on this package. It's very comprehensive. I also very much appreciate our staff recommendations across the board, as well as the input from the public to modernize our regulations. A few comments since I was not here at the October meeting. I also appreciate the proposal to update our regulations to gender neutral language. This reflects changes that are also being made at the state legislature, as well as in other areas of life. And more importantly, it ensures our language reflects the principles of inclusivity that we strive for. I did have one technical question on the representation proceedings in proposed 20300B regarding electronic signatures. I believe on a petition for representation. Let me just check.
Petition for certification.
Petition for certification. Can you just walk through, and we may need assistance from council, how that would work? It would just be like an e-document, or what's envisioned for allowing electronic signatures?
B, okay.
Barry and Ralph, would you like me to chime in?
Yeah, I think it would be best if you did, Todd. At least error prone.
I think that this is to sort of smooth the way in conjunction with the other e-filing proposed fixes for a petition for certification to be electronically filed. You would still need to have whatever signature sheets included with the petition, but just for the petitioning party to submit it to the board would allow for the electronic filing of that document.
Okay, so that would not allow for electronic signature. Because right now the proposed language says a petition for certification shall be in writing and signed by hand or electronically.
Yes.
So it would allow or not allow for electronic signature?
It would allow for electronic signature on the petition. So for the petitioning party, the party submitting the petition.
Okay.
To submit it to the board electronically.
Okay, just wanted to make sure I understood that correctly. All right. Okay, next I will turn to the regulation that that was the focus, I think, of the report the board member Broad gave, as well as the general counsel's comments. I've given this proposal and this regulation a lot of thought. I did watch the initial hearing in the haze of having a 6-week-old baby. And again, more recently when I had a little bit more caffeine and rest, just so I could make sure I could fully appreciate the staff comments. First, I think I want to reiterate, I think the board is incredibly lucky to have such a talented general counsel, as well as such a talented general counsel team, the staff, the regional directors, everyone in our regional offices. I've been inspired and really impressed with their dedication, their experience, and I want to echo what others have said, that I think we share the same goals of efficiently resolving matters and ensuring that we can rapidly get the justice needed as appropriate for workers. I also appreciate the challenges, both with COVID, which has been a huge issue, obviously, for the last few years, but other challenges. The general counsel and the executive team and I regularly discuss larger administrative issues, which I know can impede the efficacy of our operation. Things like problems with telephone lines, internet access, modern equipment, the issues with vacancies. I think all of that has a very real impact, and one that I very much appreciate. And it's not always evident when the case comes before the board how those impacts have affected us. And so I take that seriously. Additionally, I've never been an investigator. I've only been in this role and other kind of policy, more arm's length role. So I really defer to our staff to inform me what's going on the ground and what the challenges are. And I defer to them in terms of implications. Numerous staff at the October meeting raised the concern about how this would hurt workers. And I take that caution incredibly seriously. And it's given me a lot of pause. I have to say, as I look through this data, it's a little bit hard for me to see, I guess, average length of investigations, particularly related to complaints, and then to even know what our oldest cases are. So I started in May of 2020, so right at the heart of the pandemic. The first case that I dealt with was the Rincon matter, which is where Board Member Broad wrote his concurrence. So I just share that as background for the public and the staff to kind of help share what's informing my experience and sort of what I'm bringing into examining this regulation and the need for it. Additionally, as I've met with stakeholders, I have heard concerns, not just from the employers, but more from some of the labor organizations about filing charges and not and having concerns about the timeliness with which they're dealt with. I think there's also concerns regarding, if a worker files a charge and it's been a year, 2 years, or more, and they're not seeing any results. As we discussed, they are putting their name on the charge. So it's out there. They're a known entity that they have taken the time and the courage to stand up to, in many cases, their employer and say that their rights have been aggrieved. And I think that's incredibly brave and incredibly serious. And I know the General Counsel's office shares our desire to then resolve that as quickly as possible and hopefully stem the tide of further retaliation. That being said, I want to make sure that we're very thoughtful in how we go about proceeding. And again, very mindful of what our staff have shared and that this will hurt workers. And I definitely do not want to do that, but I do, like I think everyone here, want to see cases move farther. So I would appreciate that we do get, I think, monthly updates from the General Counsel. Also, and I'm open to doing this, I don't know if we can decide this in this forum, maybe we can get a proposal at our next meeting, but other ways of sharing the data, just so we can see how many cases each month are being resolved, how they're being resolved, and average age of cases as well. I also, while we, I believe, are looking to move this regulatory package forward, and I do believe it has, input from members of our staff, including the general counsel, about how to ease and reduce burdens on investigations and various processes, that door is still open. So whether it's through regulation or through administrative matters, I do want to let all the general counsel's office staff know that we, while I cannot guarantee that I can add dozens of staff or get you the latest computers, I will make every effort to address issues that are impeding your work and your ability to do your work. I think that's incredibly important. I see that as our role of the board. Obviously, we have to adhere to firewall issues and Bagley Keene and whatnot, but there are avenues to make sure that we are addressing those burdens so that you can do your work. We have to support you in doing that. I'm committed to doing that. The general counsel and the executive team and I regularly discuss these issues. It does, require prioritization. And I know there are some outstanding issues right now that are impacting workload. So I just want to assure staff I'm cognizant of that. I take that incredibly seriously, and I will make every effort to ensure we're giving you the tools and the support that you need to do that work. I also commend the general counsel for sharing the steps that she and her staff have taken to help with case review and expediting matters. I think that is incredibly helpful as well. So with that, I would welcome a proposal from the general counsel, perhaps at one of our next March meetings. There's one on March 9th, and I believe we'll have one on March 23rd, with a revised way to share data. And then I think once we have I at least have a better understanding of the baseline, maybe we can look at some metrics that we will be looking at in a year. My experience, as I shared earlier, during the general counsel's report, is from the Department of Industrial Relations and the Labor Commissioner's Office, where they have some similar programs. And we worked there when Member Lightstone was at agency legislative secretary to introduce legislation that would help strengthen the administrative tools of the Labor Commissioner. If there's an extent a need to do that for the general counsel, I welcome those suggestions as well. And we can take another look at it, but it's something I'm going to be following very closely. I want to help support the general counsel's office as much as possible in the way that I can. Board Member Broad was correct. It is not for us to get involved in the investigations, but I do think as both the adjudicatory board and the oversight board, we do have a role in making sure that the mission of the ALRA, that we continue to proceed with the mission of the ALRA and ensure that the protections and the remedies afforded to workers under the ALRA are in fact achievable and in a timely fashion. And with that, I will turn it open. I don't know if any of my colleagues have any comments, or the general counsel. Okay, I believe I will have comments from the public. Santiago, if you can go to the public comment queue.
At this moment, no one has indicated a desire to comment. Please, if you wish to comment, either raise your hand using the Zoom feature or send me a message via the chat feature.
It looks like Member Flores is indicating there's some audio issues.
Yeah,
Yeah,
I think Santiago was muted.
That's correct. I do have a individual hand up, Jesse Grewal. I apologize if I mispronounced your name. Please unmute and provide your public comment at this time.
Thank you so much. Just making sure the board can hear me. Hi.
We can hear you.
Hello, this is Jazzy Graywall, Legislative Director with the UFCW Western States Council. I just wanted to make comment today in support of the proposed regulation to add into the cannabis chapter, section 200951. Appreciate the technical and clarifying amendments that the board has, that the subcommittee added to those provisions, and just wanted to express our support. Thank you.
Thank you. And is there anyone else that wishes to provide public comment at this time? Please raise your hand or send me a message via the chat feature. There does not appear that anyone else has their hand up or have said, I'm sorry, I have one here. Nope, that was Jassy. There's no one else, Chair, at this moment wishing to provide public comment.
Okay, thank you. Thank you everyone again for your hard work and for your feedback. I believe we need a motion to get on to the next stage of rulemaking. Board Member Broad, can I have a motion?
Yeah, I would make a motion. I think this is the appropriate motion that the board approve the report of the subcommittee and move to promulgate the regulatory package, formally promulgate the regulatory package that is before the board today.
Okay, I have a motion. Can I have a second?
Second.
Board Member Lightstone, all those in favor, aye?
Aye.
Aye. Let the record reflect the 4 board members present voted aye. Thank you. On to the next steps. Okay, moving on to agenda item number 10, the personnel report. We have no personnel items to report. So I'll move into final public comment. Do we have any public comment?
Not at this time.
Okay, thank you. Our final agenda item is for announcements. Please note we have a regional directors meeting today at 2 p.m. You can see the agenda on our website, which has new and different dial-in information other than the ones you use for this meeting. The next public board meeting will be on March 9th. And with that, this meeting is adjourned and the record is closed. Thank you.
Do we go in?
We do not have a closed session today.
Okay, all right.
Okay, thank you. This meeting is adjourned.